please stay on the course. What happens often is I'll get an email later in the week, says my credits weren't uploaded. I'll go and look at the sheet and I'll see it's a manager that stayed on for about 10 minutes out of the 1 hour. So please try to stay on for the duration of the class if you want your credits uploaded, and we'll make sure that it happens. And the other thing I want to mention before we introduce our instructor for today is anything you hear today is to be considered as informational purposes, educational purposes only, should not be considered as legal advice. We'll open up the Q&A later. We'll answer some general questions, maybe the first 5 to 10 questions there. You could put other questions in the evaluation. But again, this is just informational. So if you do have official questions, contact your association counsel. And if you don't have one, I know one that's more than willing to help you out. And we appreciate you being here today. I want to call upon our instructor today to start your feed. Alan, come on in. Alan Schwartzseid, our managing attorney, excuse me, of the firm's Orlando office. Alan, the floor is yours. My friend, happy Halloween to you. I love your costume.
Thank you. I'm actually following your lead from this weekend on Figment. So Jeff spent the weekend at the theme parks in Orlando. He was in my neck of the woods. We got to meet up for about 20 minutes. And anyway, moving along, I also appreciate Jeff throwing in the little song at the beginning. It's good that he wasn't on key enough necessarily to risk some kind of copyright infringement claim against me or the firm. So that works out well as well. As Jeff mentioned, I appreciate everyone being here for our community association collection. Should I pay or should I go? Thought that was a little bit creative. As Jeff mentioned, I'm the managing partner of our firm's Orlando office. We've got 4 offices, one here in Orlando. We've got an office in Tampa. Our main office is in Pompano Beach, which is basically Fort Lauderdale area. And we've got another one in Palm Beach Gardens, which is West Palm area. We've got 21 attorneys, 8 of whom are board certified in community association law. This is all we do, except we've got 1 board certified attorney in construction law. So when you have construction defect issues that come up in your community, those are also issues that we largely handle in-house, although we do refer some of them to other qualified attorneys. But we've got someone in-house to handle that stuff. I don't think there's a ton of firms in the area in Florida that are doing that in-house and where you don't have to deal with multiple different attorneys. But long story short, we're happy to present this seminar. We hope that if your community ever needs help, you'll remember that it's literally all we do within our firm is represent community associations and work with them to try and make them operate as smoothly as possible. If you've got issues that are coming up, you've got amendments you need to work on, this is probably the last pitch I'll give, other than maybe our collections program itself. Within the discussion of collection, mortgage foreclosure, and bankruptcy, which is what we're going to be discussing today. So I'm going to share my screen real quick. Hopefully you guys can see the slides that are up there. And so let's go ahead and move right into the presentation. I'm sorry?
Said yes, we can see it. Looks good. And okay. Alan, as you're getting situated, I want to mention one last thing.
Sure.
As we get to about 15 minutes left today, I'll enable the Q&A. That's where you will type your questions. And so we're going to hold off on enabling it now because more often than not, a lot of the questions that come up are answered during the course of the presentation. And again, if we do not get to everybody's question, and I know we won't, we have a couple of hundred of you here today. We'll get to about 5 to 10 of them, and as many as we can, time permitting. Alan, back to you.
All right, thank you. So I want to start by saying if you ever have issues in your community and you're not really sure what to do or who to contact, my email address is on this first slide right here. It's as@kbrlegal.com. I'm very glad that my partners, when I rejoined the firm a little over a year ago, were willing to give me an easy email address because Schwartzseid@kbrlegal.com is still pretty long. So this is a quick and easy one. All right,
moving you can see your full name from outer space, by the way. So
yeah. Exactly. Moving into the actual materials, why are we actually able to say you owe this money and we can foreclose your property if you don't pay it? This is the first most crucial factor that the board needs to understand when you're collecting unpaid assessments. So the Florida statutes, and specifically the chapters governing, and these are 718, 719, and 720 pertaining to condos, cooperative associations, and HOAs respectively, and also your declaration, are going to specifically say that your assessments pay the cost of operating and maintain your community or whatever other purposes are listed in your governing documents. The reason that you're able to foreclose these items and lien for these items and have a superior lien to pretty much anything other than usually a first mortgage against the property and property taxes is because this declaration, your governing document, the contract between your members and the association, was recorded before anyone purchased the property from your developer. And it says the association has the ability to foreclose its lien if owners don't pay assessments. So that declaration, as well as the Florida statutes, are the reason when people say you can't take my house because I didn't pay assessments, they're flat out wrong. So just keep in mind, and that's not the goal here, by the way, just so you understand. When we go through all this information, the goal is not to take someone's home. It's not to make someone homeless. It's not to take away an investment property. It's not to have the property sold so that the association is paid. It's to get the association paid in full in as timely manner as possible after the owner fails to comply with their legal obligation under this contract, the declaration, to pay the assessments. So the way that we generally determine the maintenance assessments is what we call them, the general assessments, is by the annual budget. You basically take your budget, divide it by the number of lots or units in your community. It may be split a little differently depending on your declaration, but usually you just take it, divide that number by the amount of properties in your community, and that's what each member pays for the year for assessments. That may be split monthly, it may be split quarterly, it may be just one annual payment per lot or per unit, but generally speaking, you get your assessments from the budget. So you take your entire budget of what you are anticipating is going to be spent throughout the year to properly operate and maintain the community, and you divide it up among however many lots or units you have. Now that's different from a special assessment, which is basically one that's not included in the budget. Sometimes you have a special assessment that should have been included in the budget, but that's not what we're going to talk about today. These are the ones where you've got your governing documents, they say what's required and what types of special assessments you can pass. Now, that may be an individual assessment from self-help or something else as well. It's basically, we're talking about anything other than your budgeted assessments. Okay, those are going to require at least 14 days notice that the assessment's being considered, what the purpose of the assessment is, and the estimated costs. That's all going to have to be either posted conspicuously on your property or mailed or hand delivered, which don't do hand delivery, by the way, or it can be delivered electronically if the individual members authorize it. But you need to give all of your members notice before you adopt that type of special assessment, which again is not your general budgeted assessment. It's going to be something specific that you realized after the fact, or it's something that is only going to be done once and it's only this year. It's not a recurring assessment that you should have already in your budget. Keep in mind, what you should be doing is properly budgeting for everything you think it's going to cost to maintain and operate your community this year. The fact that you don't think your members will like your budget is irrelevant to the board's fiduciary responsibility to the association to properly budget for what it's actually going to cost. So if you have to increase your budget $1 million over last year, you may have restrictions in your governing documents that say you need to get member approval. Without those restrictions, or if those restrictions say a member can raise the issue, which is the case in condos with this 115% rule that I think we'll get into at some point, unless it says in your governing documents of the Florida statutes that the members can bring it up, it's the board's obligation to raise the issue and say, hey, we really need to increase this budget significantly. And we as directors have a fiduciary responsibility. That's the most important duty imposed by Florida law, to actually have a proper budget. We can't underfund the budget on purpose just so that the board looks better. Okay, moving along from that, we talked about once the assessments are levied, we talked about why can we foreclose, but the invoices or statements need to be delivered to the owner. In other words, you should be telling people, here's what you need to pay this year for assessments. Okay, that can be sent via first class US mail, electronic transmission, or to a registered email address. Now, when I say or, what I mean is technically the association could also fax it if a fax number is what was given. Don't fax anything, either email it or mail it out. You can't change the delivery method. This just came about 2 years ago. It was a change to the statute. And it basically, if you are changing your delivery method for invoices, meaning you're changing the format, you're changing how you mail them out, etc., whether they're emailed versus being sent in the mail, whether you're using coupon books versus just an annual statement that goes to each member, you can't change that unless the owner receives notice and actually agrees to and affirmatively acknowledges that they understand the association is going to change its delivery method, or you may need to deliver those notices differently to each property. So for example, if you used to have, last year you had these notices, the assessment notice was sent in the form of a coupon book. And this year you think that's a waste of money. We're not going to spend the extra money to send a coupon book that everyone sends a coupon back if everyone's paying via ACH or whatever the automatic payments are called. Okay, why would we waste all of the association's money having those coupon books printed if we can just say, here's your invoice, pay it every month as it comes due? Well, after you send, if you're going to make that change, you need to send out a notice to the members, letting them know it's going to happen. It needs to be at least 30 days before that change takes place. And each member, each lot, each unit needs to actually write back saying, I understand and accept this. If they don't write back, and I think this is an absurd statute because they can avoid the change by just not responding. I'm hoping that this will be revised soon, but can't promise anything. If they don't respond, you still need to use those coupon books for those particular members. So it's a nice big mess. We're hoping that that will be fixed, but bottom line, you need to provide notice if you're changing your delivery method for the invoices saying what each member, each property owes for each year's assessment. Okay, what is a delinquency? Keep in mind, it's not just you didn't pay on time and you're now delinquent. The delinquency is actually defined directly in your declaration. So you need to actually either look or preferably have your attorney take a look and tell you what is a delinquency in our particular community. How is that defined? Is it the day after the assessment was due? Is it 30 days after the assessment was due? So keep in mind, it's not just this is late. That's not the same as a delinquency. And that does make a difference under Florida law, because there are a lot of statutes that say if the account is delinquent by X amount of time, or if the account is delinquent. It doesn't say if the account is late. So you need to know what that delinquency date is for purposes of pretty much any collection activity or any other enforcement based on a past due balance. Okay. Once that delinquency arises, all of the payments that are made by the owner, this is very important. So you need to pay attention to this factor in particular, more than a lot of the other stuff we'll discuss today. Any payments that are received by the association must be applied in this manner. First to accrued interest, then to late fees, then to attorney's fees and costs, then finally to the oldest unpaid assessment. The statute is very specific. Keep in mind, if you don't apply the payments this way and you treat it as though, well, the owner said that this payment is intended towards just the assessments, so we're going to listen to them. No, you listen to the law, and the statutes specifically say you must apply the payments. It uses the word shall. All payments shall be applied, first to interest, then to late fees, then attorney's fees and costs. It actually says costs and attorney's fees, but lumps them together, so it doesn't matter. And then finally to the unpaid assessments. So if that owner says, well, I paid the amount of the assessment and I'm current. No, that payment, if you were already delinquent, gets applied first to the interest, then the late fees, and whatever is left gets applied to the assessment if you don't already have attorney's fees and costs incurred in collection. Unless the declaration says otherwise, you are allowed to charge interest, and that amount will be 18% per year, which is the statutory maximum. So if your declaration, your bylaws say you can charge 15%, that's the amount you charge. If your declaration says you can charge interest but doesn't give an amount, you can charge 8%. If your declaration is silent on interest, you can charge 18%. Now, when it comes to late fees, that's a little different. You actually have to have direct authority. Whereas with interest, you can charge it automatically pursuant to statute. The statute specifies that you can only charge late fees if the declaration or bylaws say so. The maximum amount of late fees that you can charge is $25 or 5% for each installment. The way I see a lot of associations doing this wrong is charging $25 or 5% per month. Well, if your installments are quarterly or annual or semi-annual, then you're charging too much, because you're saying, okay, well, you only owe 4 assessments per year, but we're charging 12 late fees. Doesn't work that way. So you need to make sure that you're charging 1 late fee per installment, or even though I don't like it this way, at a minimum, breaking up the late fee so that it's a monthly charge toward that installment. So for example, you charge a third of that quarterly assessment, you charge a third of that $25 every month, so that after you've hit the next installment, you're still only charging 1 late fee of $25 per installment. Again, this needs to be in the declaration or the bylaws. Otherwise, you can't charge a late fee at all. Costs and reasonable attorney's fees incurred in collection are recoverable regardless of whether a lawsuit is filed or not. That's why the statute is clear that the payments are applied first to attorney's fees and costs, and only after all of those fees and costs are paid does a payment get applied to the assessment. So keep in mind, this is different from your standard covenant enforcement, where unless your declaration clarifies, and this is an amendment that I do fairly regularly for communities, unless your declaration clarifies in a covenant enforcement context or pretty much any other context that you're dealing with a community association that's demanding enforcement of its rights, here in collection world only, when you're demanding payment of assessments and unpaid amounts that are accrued on assessments, you get an automatic immediate right to recover your attorney's fees. So we talked about owners that are alleging that they paid in full, but they only paid the assessment amount. If any other interest, late fees, attorney's fees, and costs have accrued, then they're wrong in saying that they're paid in full. So those amounts get applied to the interest, late fees, attorney's fees, and costs, and whatever is left gets applied to the assessment. Once an account's delinquent, keep in mind, my practice is every single action that the association takes or that its counsel takes should lead to obtaining that payment that the association wanted in sending that account over to counsel, or advancing the collection matter, meaning you're moving towards foreclosure, or both. I prefer both, because what you can do is use proceeding with collection as appropriate under the law as a negotiating tool. Okay, we're going to move forward unless you settle this. We have no reason to hold off unless you actually come to the table and say you're going to enter into a written settlement agreement that's going to contain actual consequences for defaulting. Okay, so when you enter into that settlement agreement, we'll talk about in a minute, it's not a good idea to have a verbal agreement or a written agreement that just says you're going to pay the assessments and related charges by this date. Okay, you want to have very clear consequences for what happens if an owner does not comply with that written agreement. You should also put in place a collection policy. So you're putting the association in a better negotiating position for settlement purposes. The other benefit of a written collection policy is that you can clarify how the notices are issued, when they're issued, whether there's any kind of break in between each notice, or if you're going to send this and the board doesn't even need to be consulted, management is going to proceed with all of these notices, and there's not going to be a board meeting before the next step in the collection process is taken. That's how I recommend you put your collection policy in place, where it's automatic. If you're 30, 60, 90 days, anything beyond that, I wouldn't recommend for an association. But if you're 30, 60, 90 days, whatever the policy says, delinquent, it's automatically going to be turned over to send that first notice. You're not delaying, you're not waiting. I've seen communities that waited 3 to 4 years before beginning a collection action. All you're doing is guaranteeing a larger non-payment by waiting. You're not helping the owner. You're actually making it harder for them to come up with all the money that they now owe you by waiting longer to send a demand. You're also creating potential defenses to your foreclosure action, which you certainly don't want to do. We'll get into that later. Keep in mind, I talked about the application of payments. If you don't accept a partial payment, the judge can actually rule, and this is in the third bullet here, that you've waived your attorney's fees and costs incurred after the rejected payment was delivered. In other words, if someone says, well, I only have $1,000, but I owe $50,000, you accept the payment, you apply it in the way that the Florida statutes require you to apply it, and you move forward with the rest of the collection process. But at least you're allowing them to reduce the balance to some extent. You can't just tell them, we're not accepting payments other than payment in full. I've seen communities get themselves in trouble doing that. And frankly, it's caused me to have to close out collection matters because they didn't want to incur the additional attorney's fees to complete that type of foreclosure action. So keep in mind, you're risking your entire collection process and all of your subsequent fees and costs if you reject a payment. Bottom line, don't do that. Simple. Settlements. It's always tease. A lot of owners want to resolve those debts, but they don't have the funds to pay in full. Like I said, you might have waited too long if you don't have a good collection policy in place. And those collection policies are something I draft on a daily basis, or maybe more like weekly. But the bottom line is every community should have a good collection policy in place so that everyone knows what's going to happen if they don't pay on time. Same with a covenant enforcement policy. If you have these policies in place and you're telling everyone in advance, this is what's going to happen. One, everyone should know how you're going to move forward with the collection process and that you will move forward with the collection process. And two, they know exactly what to expect as to when you're going to move forward. So they're not going to sit there thinking they have 6 months to pay this off when you know your collection policy says that within that first 6 months, you've sent 3 notices and several of them came from counsel. When you're trying to get these things resolved, you can give a little bit. It's not we want it all or nothing. We want it all or we're moving forward. That's a bad idea. And I know that sounds like a weak argument and that's not as aggressive as a lot of communities would like to be, but here's why it's a bad idea. Okay, you're not just saying, like I said earlier, you're going to pay, and if you don't, I don't know, we'll move forward. You're going to make them waive certain rights that they would have otherwise had in exchange for giving these owners time to pay. So I've seen communities that'll give up to a year, and in exchange, well, you know what? Because during that time, we would have maybe completed the foreclosure process, let alone started it. If we hadn't entered this agreement, they're going to give us a quitclaim deed. We're going to hold that in escrow. And if they default, instead of having to go to court, instead of starting from scratch, we're just going to record the deed. Association owns the property. Done. No need to go back to court. And that is an extreme resolution. That's a listen, we're giving you way more time than we would have wanted type of resolution. If it's just 3-6 months, something like that, you can have alternatives in there. If you're not in foreclosure yet, the association gets to automatically and immediately, upon a default, record a claim of lien against the property and file the foreclosure action. That means you get to skip some of the notices that we'll talk about later. It could buy you 4 months worth of time that you otherwise would have been waiting to move forward. So in exchange for that, you're automatically allowed to move forward. What I do is usually have the owners waive formal service of process so that you're not wasting that time and money. Instead, you send a copy of the notice or the complaint once it's filed via email, and you have an affidavit from the attorney that sent it or the paralegal that sent that email saying, yep, I sent it on this date. I didn't get a bounce back or whatever. That's your service of process for that owner. And then you only need to go out and serve the other defendants that are named in that case. Okay. The one important thing that I will say, now, there are plenty of options, by the way, as to what the consequence of a default might be, but just make sure that there is a consequence. That's the biggest thing. Having these agreements, part of the reason that a lot of communities don't want to reach these agreements for payment over time is because they're just sending emails back and forth saying, okay, well, you'll agree to pay it. And if you don't, what? We move forward with the standard process. That doesn't benefit the association in any way other than the hope that this will allow the owner to pay. Okay, what you want to do is you're giving the owner a significant benefit in saying we're not going to immediately move forward and follow through on this process in exchange for you giving up some of your rights. So if your attorney is not forcing these owners to actually give up some rights in exchange for entering this agreement, that's probably not an attorney you want to work with on collection. Moving on. Don't do a verbal agreement with anyone about anything, period. Very simple. Every agreement should be in writing. That way there's no he said, she said, there's no trying to figure out what the actual terms that were agreed upon are. You know, you want due dates in dollars written into your agreement. What happens if the association finds that the owner defaulted? You want all of that in writing and clear. So I recommend you have a written agreement, not just an email, but something that is physically signed or digitally signed, so that you can go back to a judge later and say, Judge, this is what they agreed to. I don't care about any of their other arguments. They didn't follow this agreement. Regardless of what's in the declaration, they didn't comply with what they said they would do. Now, that agreement should also require not just that they pay back what they owe, but that they make every payment that accrues during that agreement. So if they're sitting there and you give them a year to pay, then every assessment that comes due during that time, if they don't pay it, that's another default. And you proceed under the default provisions of that agreement. The attorney's fees and costs incurred preparing and monitoring the payment plan are also something that should be included. Why would the association be responsible for that if the owner's the one that caused it? Why should all of the other members pay to benefit this owner? Don't. Issues that come up fairly commonly in the collection context, inaccurate accounting, and that's not me blaming any specific management company. I have accountants that cause problems because they don't have proper interest calculations, because they calculate it once a month instead of daily, the way that it accrues under the statute. The association sometimes accept payments without telling the attorney that is in the collection process. They provide a ledger. If you provide a ledger to someone, that is their estoppel. You know how you send out an estoppel certificate when someone is selling their property or refinancing, they request that estoppel certificate and it says, here's what you owe. That's the same thing. If they get a ledger and they pay based on that ledger, they have a legal defense, and we would have to shut down that entire case. We would have to close everything out. So make sure that once you turn an account over to counsel, you're telling them about all payments or providing the payments directly to the law firm to apply to the account. And you're shutting off any access to ledgers. You're not giving any information regarding that collection account, the assessment account. Every piece of information that owner receives should come directly through the attorney. That way you can't screw it up. And frankly, if the attorney screws it up, then it's on the law firm and not the management company or the association. Okay. Tax details can also become a problem. These will eliminate all encumbrances, meaning all liens against the property, including first mortgages and association debts. So that first mortgagee, if you're trying to get the surplus that's left over after that tax detail, which, by the way, a tax detail means the property taxes weren't paid and the county actually followed through the entire process, which I had an article on, and I can write a new one or write an email if you want to email me if this is something that interests you. But bottom line, these are sales that are conducted by the county for unpaid property taxes. And a first mortgagee is going to get that surplus money, if there's any money left over after paying what's owed for the taxes, before the association gets it, but request it anyway. And the reason for that is sometimes the lender screws up and doesn't ask for that money. And at some point, if they don't ask for it, then the county is going to look at who did ask for it and disperse the proceeds after they figure out who is probably entitled to it, which might include the association. Mortgage foreclosure and bankruptcy will also hold up the association. We'll get into those later. Sometimes judges don't know this area of law. And I say sometimes, I will actually correct that to frequently. Judges don't understand community association law, don't understand collection of assessments, the law governing that assessment collection. And they make determinations based on what they unilaterally think is fair, regardless of what the law or the contract, being the declaration, actually requires. Judges also get to determine what amount of attorney's fees is reasonable. So a lot of times, and I won't say frequently, I won't say most of the time, but sometimes you'll see judges actually cutting the fees so that the owner doesn't actually have to pay all of the fees and costs that were incurred by the association in the collection process. That doesn't happen very frequently with our firm, but I do see it happening more frequently in other areas of law or with judges that customarily deal with mortgage foreclosure issues and think that, $1,500 to $1,700 is a reasonable fee to get through an entire case. I don't necessarily agree, but it's up to the judge. Alternatives and supplements to the collection process. So when we say the collection process, we're talking about what we're going to get into in a minute, which is all of your notices that are required by Florida law. But you can also send a rent demand notice. So this is a statutory form letter that basically goes out to a tenant and says, hey, you didn't pay, your owner of your property owes some amounts. You're not going to specify because we'll get into fair debt laws later, but your owner owes some amounts to the association. You need to pay all of your rent to the association until that is paid in full. Now, this is something that I prepare forms for management companies and for self-managed communities all the time. It's not something that needs to be specific to the property. If there's a delinquency and you happen to know that there's a tenant, send this notice out. If they don't pay, the problem is your only remedy is you can evict the tenant. That tends to be productive in communities where they're going to get a new tenant in almost immediately that might pay. It's not so productive in communities where you have like one rental a year. But keep that in mind. And frankly, it should be something that you bring up to your counsel if it's not something they're already doing. Suspension of voting and or use rights. I'd suggest you check out our covenant enforcement webinar for a bigger discussion of those issues. We do have all of our past courses that have been recorded on our website at kbrlegal.com under the resources tab. So if you check out the covenant enforcement seminar, there's a bigger discussion of this issue. Frankly, we just don't have the time today. You can move forward the lender's foreclosure action, basically take action to either advance it or have the judge dismiss it because the lender's not doing anything. You can schedule and or attend hearings in those cases, schedule a case management conference, move for judgment on the pleadings, which basically says all the documents that are in the court are enough for a judge to say, hey, enter this judgment. Or for you to say, hey, judge, enter this judgment, and the judge should do it. Similarly, there's a procedure called a motion for order to show cause. That can take some time and be a little costly, but it's almost like an abbreviated foreclosure action. When it's appropriate, it's extremely effective. You can move to dismiss the case for lack of prosecution if the lender's sitting around. That'll usually get them off their behind and get them moving forward. If there's been a foreclosure sale, you can seek surplus funds, or if there's a tax deed sale, same thing. So those are things that you can use to get your money back, even though they're not technically directly a part of the collection process. So let's briefly go through, because we are starting to run short on time, the collection process itself. Pre-suit phase is the start of this process. The first thing you need to do when someone's account goes delinquent, and sometimes you'll have another notice that goes out, it's kind of a courtesy notice that goes out from the management firm saying, hey, your account is past due, you need to pay your assessments and all the related charges, or we're going to send out a notice. That should be something that goes directly in your collection policy as to whether it's going to be sent or not. If it says that you send it, you send it. If your collection policy is silent, or your collection policy says the first notice is going to be this notice of late assessment, great, move forward. Now, the notice of late assessment is the first statutory notice that needs to go out, before you send this account over to counsel. You cannot charge attorneys' fees and costs in this letter. It's statutory, you can't charge attorney's fees. It's questionable whether you can charge costs. It is risky to do that. This is a letter that basically says, here's what you owe. You need to pay it within the next 30 days, or we will move forward with the collection process. Okay, if that letter is sent and expires, unfortunate, but you can move forward with the next step. Another thing that's not mentioned here, but I will mention, we prepare this form notice for our communities all the time, and then they can use that form for every collection matter going forward. And because they're using our form, we know that we'll be able to move forward with collection once that letter expires. The other thing that you should be using is an affidavit of mailing this notice of late assessment. So if you have that affidavit that's signed by presumably the person that sent it out at around the time that the notice of late assessment was sent, the courts actually have the obligation to presume that you sent that letter. So the burden shifts from the association to prove that you sent it out to the owner to prove that you didn't, which you're telling them by statute, you must prove a negative. It's almost never going to result in a favorable result for the owner. The next notice that you're going to send, once that expires, some management companies send this, we will send it out if we are your counsel, is a notice of intent to file a claim of lien. Now, instead of being good for 30 days, this one's good for 45 days. And again, it's going to say, here's what you now owe. And we're going to record a claim of lien against your lot, your unit, if you don't pay in full by the due date set forth in this letter. It actually just says you have to pay within 45 days, doesn't provide a specific due date. This is going to be sent via certified U.S. mail, return receipt requested, with a copy via first-class mail, whereas the notice of late assessment was only sent via first-class mail. Okay. This letter is not statutorily required, but it's recommended anyway in cooperatives. It's hard enough to get a judge to understand the law regarding these issues. Why would you add complications? Just send out the notice. And frankly, a lot of times, this is the notice that results in compliance and payment by your owners. In a condo or an HOA, you can't record a claim of lien properly unless this letter is sent and expires. So keep in mind, this basically is a 45-day notice saying, here's what you owe if you don't pay. We're going to record a claim of lien against your property. Okay. Next, you record your actual claim of lien in the county public records. It's going to secure all post-recording assessments, interest, late fees, costs, and attorney's fees. So you don't have to start over every time an assessment accrues. But post-recording special assessments are not automatically included. So you would need a separate lien process regarding any special assessments that accrue after this lien is signed and recorded. Now, the lien statutorily dates back to the recording of the declaration, meaning that the priority that this lien is given is as though it was recorded what could be 50 years ago, depending on the date the declaration was recorded. However, the declaration may expressly limit that lien period to only after a claim of lien is recorded, meaning it doesn't relate back. So you need to look at your declaration, or more likely, your attorney needs to look at your declaration to determine the priority of that lien as compared to all other liens against this property. Now, just because there are other liens doesn't mean you can't foreclose anyway. Just keep that in mind. So I'm not saying that you have to know this information in order to record a lien. It's just useful for the board to be aware of what position you may be in and whether some other lien might wipe you out, including a first mortgage. So you are given a limited super priority over a second mortgage as an assessment holder or other junior liens, but you will almost never be superior in that lien to a first mortgage lien unless the first mortgage was recorded after your claim of lien. Now, even in that case, you got to look to your declaration. You're generally going to be subordinate to ad valorem taxes. That's the taxes, the property taxes we were talking about earlier that can wipe out the association and even a first mortgagee. Condo and co-op liens, keep in mind, you only have 1 year from the date that that lien is recorded to file your foreclosure action. You don't give up all your assessments if that's not done, but you have to start that lien process over and send a new notice of late assessment, a new notice of intent to record a claim of lien, etc. So you don't want to let that lapse. You don't want to wait that year. Either decide that you're going to go forward from start to finish, or don't. Don't waste your money. Don't waste your time. By the way, my recommendation is move forward, period. Be aggressive, because honestly, this is how you fund your community, how you operate and maintain the community. If you're not aggressively collecting your assessments that people aren't paying, you're not going to be able to maintain your community the way that you're required to under the declaration and under Florida law. So moving on, the statute of limitations, meaning the time frame when an HOA can record a claim of lien and then file a lawsuit, is actually 5 years. Now, I'm not going to get into how that statute of limitations applies. You need to consult with your attorney if you're debating whether or not you still have time to file a lawsuit. But bottom line, if you've waited 5 years, you've waited far too long anyway, whether that's from the date that the first assessment accrued or the date that you recorded a claim of lien. You need to move forward quicker than that, is my personal legal opinion. Finally, the last pre-suit notice is a notice of intent to foreclose your claim of lien. So basically, this is the exact same thing as the notice of intent to file the lien. The only difference is you've already got your lien filed. So the threat that's included in this letter is that you will actually file the foreclosure lawsuit if the payment is not received. Now, once you record your lien, owners can require that the association file the foreclosure lawsuit within 90 days or have to start over. This is by recording what's called a notice of contest of lien. I've seen that done twice in my career. And that's since I've been in this particular industry since 2010, doing collection exclusively for about 8 years. So it's not used often, but if you get one in, just understand that 1 year or that 5 years turns into 90 days. Even if the intent to foreclose or notice of contest of lien hasn't happened, the intent to foreclose hasn't expired, and the notice of contest of lien, excuse me, I need a sip. If it hasn't happened, condos can file suit as soon as the lien is recorded. But if the owner pays all of the assessments, even without the interest and late fees potentially, and even without the attorney's fees and costs potentially, before you actually get a final judgment, you won't get an award, or you shouldn't get an award of your attorney's fees and costs. Bottom line, wait the 45 days, send the notice. Very simple. These used to be shorter timeframes for condos and co-ops. That time frame matches up with HOAs now. So it's 45 days across the board, except for the 30 days for the notice of late assessment. Now, all of these notices are sent, they expire, you haven't gotten payment. File the foreclosure lawsuit. What are the documents involved here? It's the same as any other lawsuit with a little bit extra thrown in. So the complaint is basically going to be the document that says we're filing a lawsuit and here's why. Here's why we're entitled to levy and collect assessments. Here's why we're entitled to interest, late fees, attorney's fees, and costs. It's going to outline the default, the date that they were first delinquent or didn't pay the assessment. It's probably going to include exhibits, which are going to be your declaration and or your bylaws, the pre-suit notices you sent out, the claim of lien. Basically, it's supporting your claim with documentation. You're not going to include every document. You're not going to say, here's a ledger. Okay, you're just going to say, here are the basic documents that show that I've done what I need to do to be entitled to file this lawsuit. Another document you might include is a lease, or you should include, is a lease pendens. This is a document that literally means there is a pending lawsuit involving a parcel or unit of real property. Once that's recorded, it places the world on notice via what's called constructive notice that there is a pending lawsuit against this property. So anyone that runs a title search for purposes of purchasing the property, refinancing, mortgaging, whatever they might be doing with the property is going to have this lease pendens pop up. A summons is another document that's going to be issued by the clerk for each defendant, and that gets served along with all of these other documents. And the owner has 20 days to respond to the lawsuit after they receive this via process server or however you've agreed in your written agreement. It also clarifies where to file the response to the lawsuit and where to send it, which should be the attorney that's working on the lawsuit. The defendants are basically everyone that you would want to foreclose out. So you're going to name your owners, anyone else that has a potential interest because a deed was deficient, meaning that it might not be valid. In other words, it might not have actually transferred that property. Sometimes we'll name people that have a non-vested interest. In other words, that interest pops up later, but they're listed on the deed. Second mortgagees and other junior lien holders, depending on that lien priority that your attorney should be interpreting and not the association. The owner's spouse to foreclose homestead rights, and any occupants of the property to foreclose any tenancy rights. First mortgagees can't be foreclosed or named. Keep in mind, you can't name that first mortgagee and just wipe it out and hope that they don't respond. Okay, if you do that, you're actually subjecting the association to potential attorney's fees and costs being awarded to that lender. Now, there are a few ways that you actually can foreclose a first mortgage. The declaration says assessment lien relates back to the recording of the declaration or is otherwise superior to all mortgages. It doesn't have a lien subordination clause, meaning language that says any lender's lien is superior, or any first mortgage against the property is superior to the association's lien. And anyone that's not named in the foreclosure action as a defendant will keep their interest in the property. This is why if a lender doesn't name the association, my argument's always been that the association was not foreclosed in that mortgage lien, and the association's lien is still valid despite that mortgage foreclosure lawsuit. Okay, if the owner doesn't respond, they have 20 days to respond, like I mentioned, after they're served with process. You can request as an association that the clerk enter a default, which once it's granted, basically admits all of the well-pled allegations of the complaint. Unless that default is vacated, there's really nothing the owners can argue other than the amount of your attorney's fees and costs and some other minuscule amounts and items at that point. Basically, they're admitting that they didn't pay and that the association's entitled to some amount of damages, attorney's fees, and costs. A motion to dismiss basically says, hey, this document's not good enough. They didn't plead a proper case. The association didn't say enough in its complaint that all of the required elements of the claims that are being raised are actually pled. This is a very technical, procedural argument. It's not, I don't like what's in the complaint or I disagree. The judge is literally just looking at the four corners of the complaint and the exhibits to determine whether that document alone is good enough. An answer is going to admit, deny, or state that the owner doesn't know anything or the defendant doesn't know regarding each allegation of the complaint. It might allege affirmative defenses, counterclaims, cross-claims, etc. Court documents filed without counsel involved, including all of these, the motion to dismiss, the answer, the responses, a lot of times they're deficient. So you might have to strike those documents or have the court require that the owner kind of clean them up so that you can even deal with them. So that's something else that can delay is this owner filed something. They're talking about a covenant enforcement matter from 10 years ago that has nothing to do with this case. I'm not going to let that stand, but I can't tell that it's an answer. So I'm going to try and get the court to knock that out. So there are procedural and other reasons I might want to do that for strategy or otherwise. There are also strategic reasons I might choose to just move forward. Basically the timing. Okay, you have limited defenses if you get caught not paying your assessments. So the obligation to pay assessments is conditioned solely on title ownership and proper budgeting. So in other words, if the assessment was proper, there's really no defense unless the association screwed up something else. So if the board is doing something you don't like, that's not a reason to say I'm not paying my assessments. An owner might argue estoppel or waiver. You gave a dollar figure. You got to stick to it. Sorry, you're stuck. Even if that disclosure was inadvertent, that's game over. That's what we talked about earlier with the estoppel argument. You put something in writing. I paid the amount that you put in writing. You're done. The statute of limitations is the other one. We talked about 5 years for an HOA. It's 5 years for any amounts in a condo or co-op as well. And it's 1 year for the actual lien of a condo or co-op. Again, it's not clear under Florida law what event triggers that 5-year timeline. So that's what you'll want to discuss with your counsel. Then we go to summary judgment, which is basically, Judge, there are no facts, meaningful facts in dispute here. It's pretty clear that we're entitled to a judgment. Judge might grant that, okay, without requiring a trial. That summary judgment is going to be determined by the court. If you go to trial in a foreclosure action, that is a non-jury trial unless your attorney made some kind of mistake and didn't strike a jury demand. So keep in mind, these foreclosures are tried just by the judge. You don't have to impanel a jury. The jury doesn't get to decide. It's the judge decides based on the facts and the law, who wins, who loses, and what the award is. A final judgment is basically a document that hopefully gets entered at the end of a case saying, here's what's owed. And if that amount is not paid to the association by a date certain, the association gets to move forward with a foreclosure sale. So this is basically eBay, but for property. It's held online. It might be held at the courthouse. Property sold to the highest bidder. The winning bidder is going to deposit at least 5% of their bid before the sale, and they need to pay the remaining balance by noon the next day. Otherwise, the sale's not completed and you need to set a new sale date. The clerk might do that for you. They're mostly not going to take the time to do that. So you're going to want your attorney to be watching what happens at the sale. The attorney is not necessarily the one that's going to go to the sale. The board is not going to go to the sale. You're probably going to have your process server physically go out there if it's held in person. If it's online, yes, your attorney will probably handle that for you. Association's entitled to bid in the amount of its final judgment, plus statutory post-judgment interest without paying anything. So you're entitled to a bid of up to that amount. The purpose of this foreclosure sale is not so that you get the property if the owner doesn't pay. It's actually to try and get a third party in there. So if there's no one else other than the association that bids on the property, the association buys it for $100. If anyone else bids, those bids go up and up and up and up. up to the amount of the association's judgment plus post-judgment interest. Okay, if someone is willing to bid more than that amount, they get the property, but the association gets paid back by the clerk of court with the funds that were paid to complete this sale by that third party. If the sale is completed, if there is a remaining balance, don't forget, if your attorney's doing this right by including a money judgment, presuming there hasn't been a bankruptcy, a money judgment's included, you are going to be entitled to a money judgment for the deficiency, which is, let's say this only went for $100 because the association is the only one that bid at the foreclosure sale, and the property owed $10,000. Well, there's now a $9,900 deficiency that is still owed to the association, because regardless of the fact that the association got ownership of the property, it didn't get the full value because no one else was willing to bid any more than that $100. So that is the deficiency that you can still go after the owner personally to try and collect. Keep in mind that can be wiped out in bankruptcy, and I very rarely, if ever, see anyone going after that money.
Quick question.
Sure.
Can board members or board member family members bid on that?
So that's a good question. There is a statute that says that the directors, the officers, and the manager are not allowed to bid at the association's sale. However, at a mortgage foreclosure sale, free reign, go for it. At a tax deed sale, same deal. Okay, but because this is the sale pursuant to the association's foreclosure, it's kind of a conflict of interest to have the directors bidding on it. Not that I think that's an actual conflict, but there's a perception that the association pushed this through so that this particular person could end up bidding on the property at the foreclosure sale. So a certificate of sale is generally issued by the clerk a day or two after that final payment is made, and it basically confirms successful bidder paid the balance of its bid and the sale's proceeding. In other words, it doesn't need to be rescheduled. A certificate of title is the actual document. So keep in mind, just because you completed a foreclosure sale date and someone bid on that property does not mean that the sale is complete and that ownership is transferred. This certificate of title is the document that actually transfers ownership. Until it's issued, that transfer is not complete, and the foreclosed owner still is entitled to that property. Now, if they stay in the property after that certificate of title is issued, whoever bought that property can get a writ of possession issued. That's basically the equivalent of an eviction or an ejectment, but it costs a lot less. It's usually around $300 to $400, and it takes like 2 weeks versus going through an entire eviction process. This is actually something that's done. It should be issued by the clerk of court as a matter of course. Sometimes they'll require you to go back and get an order from the court, but it's basically a single document that tells the sheriff, go ahead and remove whoever is in this property. So it's similar to an eviction. What else could cause delays? What else is holding us up? Service of process. A lot of times, especially for my communities in Kissimmee or Orlando, the owner lives outside the area or even outside the country. We can't find them, intentionally avoid the process server, or we find out that the association didn't know they're deceased. And then we have to we have to substitute that party out, name the heirs, and have potentially a guardian ad litem appointed to try and locate who those heirs might be. If you get a qualifying offer, this is only an HOA issue, but the defendant can issue one of these qualifying offers at any time during the collection process. If the conditions stated in the statute apply, the case is automatically stayed for 60 days pending the owner's payment. Now, the benefit of this, in my opinion, is that it basically equates to an affidavit acknowledging that they owe the money. So you file that as part of your motion for summary judgment right after that 60 days expire if they don't make the payment they're required to pay. This procedure doesn't exist for condos or co-ops. And then motion practice and discovery. Motions for extension are filed. People don't respond to discovery. They intentionally delay your process. Estoppel, we talked about briefly. An estoppel certificate is actually that document that you give that is requested, and it's in conjunction with either a sale, a transfer of the property, or a refinance of the property or another mortgage. It's basically, here's what's owed, here's what's problematic with the property, here's what's going to come due during the 30 days or 35 if this is sent by mail, that this document's going to be good for. Okay, if you find out that there was a problem, that some information changed or you didn't have all the information, an amendment is required so that this is accurate, You do need to issue the amendment, and that 30 to 35 day period starts over based on the date of the amendment. You don't get to charge for that amendment. You just have to issue it. And I know I'm talking a little fast, but we're running short on time, and I want to get to some good Q&A for you guys. This is going to be completed by the association or its designated agent. Usually that's the property manager or the management firm. And it's something that you need to supply within 10 business days after you receive the request. If you don't provide it within that time, none of the fees that we'll talk about, and I believe the next slide, are going to be something that you can charge for preparation or delivery of that document. And those fees can be significant. They're actually more than what's listed here. You can look in the individual statutes or shoot me an email if you're not sure, but all of these amounts are actually understated because it was changed within the last few years. And frankly, we just haven't updated this. But anything that's not included in the certificate is waived for anyone who relies on that estoppel certificate. Meaning if you tell someone you only owe $5,000, but you didn't consult with your attorney to find out that there's another $5,000 in fees and costs incurred, that you're under our collection program, for example, we haven't sent a bill for that because you're working with us, and we're going to wait until the end of the file to send that bill over. You didn't know about that additional $5,000. You're only collecting the $5,000, but now you're out of luck, and we're going to have to charge you the $5,000 that we have incurred in fees and costs. So just bottom line, if an account is in collection, do not give any financial information to anyone without consulting with counsel. Okay, we talked about an estoppel argument, which is the same concept. It's basically saying, hey, I got a payoff from you, whether it was intended as a payoff or not. It was a ledger that said, here's what's due. I paid it. You can't come back later and say I owe more money. Okay. So just keep this in mind. Don't give any kind of payment information if an account's in collection. Fair debt laws, or I call them unfair debt laws because they're in a large part absurdly implemented. I don't think they're a bad idea, but they basically say you can't do anything that's unfair in collecting consumer debts, including assessments that are owed by owners. You can't communicate information regarding the debt to unauthorized third parties. You can't demand inaccurate debt figures, meaning if you're even a penny off, you can be sued for a violation of this. You can't threaten legal action to which the association is not entitled. So when you're demanding payment of some of these special assessments that are not properly documented, that can be a big problem. Associations are generally not debt collectors and not subject to fair debt, but management may be, and law firms and attorneys are. Now we'll get into in just a minute that all of these people are subject to the Florida equivalent. Assessments are considered consumer debts. There's no question about that anymore. Fines as well are considered consumer debts that are subject to these acts. Now, the state law, the previous one was the Federal Fair Debt Collection Practices Act. The state law equivalent is the FCCPA, and it applies to every individual involved in the collection process, whether you are considered a debt collector or not. Okay, it's very similar. But the big difference is you are personally responsible. If you send out a demand, that includes managers, and I don't mean just the management firm. It includes directors, officers. It includes attorneys, assistants to attorneys, law firms. It's everyone involved in the process. Now, the purpose of these laws is to penalize debt collectors for improper and abusive collection efforts. But even without damages, and even where the debtor benefited from an error, the courts have actually found in the owner's favor. And the big problem with this is you don't get your attorney's fees and costs back unless you can prove that there was absolutely no basis to have filed this case. Not just we won by a landslide, but that there was literally no basis in fact or law. Basically, the standard for sanctioning a party in state court is the standard you have to meet in order to prove that you're entitled to your attorney's fees and costs to get them back in this kind of case. Moving on to mortgage foreclosures. Okay, the lender filed a lawsuit. Now what do we do? Well, keep in mind there is a safe harbor. It's statutory, but there's also one that might be included in your declaration. And proceeding is not always the best option if a lender's foreclosure action has been filed, because the reality is that lender can completely wipe out the association. So you'll want to talk, and I hate to cut this one off because it is important, but the bottom line is you'll want to talk to your counsel about what safe harbor might apply and what charges might be eliminated if the lender does foreclose before you're able to take title or preferably get someone else to buy the property at your own foreclosure sale. You should respond to the mortgage foreclosure lawsuit so that your counsel is getting all of the court documents. And when I say you should respond, I mean your attorney should respond to every mortgage foreclosure complaint. This way you know when or whether a foreclosure sale is being scheduled, and you can govern your own covenant enforcement and collection activity regarding this particular lot based on where they are and where they're headed. When I say they, I mean the lender. Okay, if you're trying to claim lien priority over another lien holder, you also need to do that within the mortgage foreclosure case. You can't say, well, I should have been able to wipe out this second mortgage if you didn't make that claim as part of the mortgage foreclosure. Lenders often delay these cases. We talked about ways of getting these moved forward. It's not quite as bad as we were seeing in 2008 to 2010, but the bottom line is we still see some of these cases taking 2-3 years to get through the court system. Whenever there's a hurricane, lenders place all these cases on hold indefinitely. When COVID hit, they did it for about 1.5 years. No mortgage foreclosure cases really move forward. So you'll want to consult with your counsel. If you're seeing that these cases are not moving forward at a pretty good click, you'll want to say, hey, what can we do? The lender filed a lawsuit. Now what can we do? Should we be moving forward or not? Now that's going to be a board decision, but you need to get guidance from counsel as to what the consequences of moving forward or not moving forward with your own collection efforts might be. Okay, unsafe harbor. So first mortgagees who name the association, foreclose, and take ownership after their foreclosure sales, or who accept the deed in lieu of foreclosure as of right now, they only owe 12 months of unpaid assessments or 1% of the original mortgage amount, whichever is less after title transfers. Third-party purchasers will only owe unpaid assessments. Neither of these types of purchasers are going to owe any pre-title interest, late fees, attorney's fees, or costs. Now, keep in mind, if the declaration provides more protection than what's in that statute that I just mentioned, the safe harbor may say that you're not entitled as an association to collect anything that accrued before that, that certificate of title was issued. Now, this is based on constitutional arguments that, frankly, we won't get into right now.
Alan,
yeah.
I don't want you to feel stressed about getting through everything. So hang on a second. Folks,
Sure.
We're a little bit past the advertised time. If you need to go and you're a CAM, I can tell that you've been on here for the hour. You'll get your credit. I don't want Alan to feel rushed because I know there's a little bit more to go. We want to get some Q&A going, so we will do that. So feel free to hang on. But again, if you must go, we get it. We're a little bit over the time. This will be on our website, kbrlegal.com, the recording within a couple of days, so you can catch up on what you may have missed. Again, I just didn't want Alan to feel rushed and potentially miss some important items. So again, one last time I'll mention, if you're a CAM and you must go, you'll get your credit. Don't worry about it. Alan, back to you.
All right. Well, we've only got 3 more substantive slides to get through anyway, so that works out well, but thank you, Jeff. Safe harbor is also going to be something that's impacted by the association owning the property before the title transfer. Okay, you're not a previous owner. You don't have joint and several liability so that everything is wiped out, but you won't get back the funds that you, the assessments that accrued while you own the property. For that reason, if the association takes title at a foreclosure sale, I strongly suggest you consult with counsel to determine whether renting or even selling that property, even with the mortgage in place and the mortgage foreclosure in place, might be a good idea to recover some of those unpaid assessments, the additional charges that you didn't recover in the foreclosure sale, etc. Moving forward to bankruptcy, this just basically goes through what the different chapters are in bankruptcy. Chapter 7 is basically you're just discharging personal liability. The liens that you have against you or your property are not affected at all in a Chapter 7. Usually lasts 6 to 12 months, and then that personal responsibility for debts goes away. So if you've got a money judgment against someone, they go through Chapter 7, they're no longer obligated to pay that money judgment. Okay, Chapter 13 will actually avoid and discharge personal liability and some liens. Only the liens that are listed in the bankruptcy plan get eliminated, okay, or that are otherwise addressed during the bankruptcy. And we'll get into how that might be addressed in a minute. The plan can last 3 to 5 years once it's approved. Now, that approval can take up to 2 years from what I've seen. It definitely takes months in and of itself. So when you have a Chapter 13 bankruptcy, your attorney should basically be taking over all collection efforts. If there is a Chapter 7, there shouldn't be any collection efforts. In a Chapter 11, this is for business reorganizations. Associations don't deal with them very frequently, but they do occasionally come up. Association liens are secured by the property, so the association gets to file a secured claim as a secured creditor in a Chapter 13 or a Chapter 11 bankruptcy. Chapter 7, your lien's not impacted, so you don't need to really do anything other than monitor what's going on. Regardless of that secured status, the association does need to file what's called a proof of claim, which is a document that says, here's what the association's owed and here's why. And that should get paid through the bankruptcy. Unless you do that, the claim is waived if the debtor gets a discharge, meaning that your entire debt is eliminated. Okay. Again, you don't need to do that in a Chapter 7. All they're doing is eliminating personal responsibility. Finally, the debtor can seek to strip the association's lien. This only exists in 13s and 11s. A Chapter 7, they can't remove the lien from the property. Okay. We won't go into the details. If you get a motion to strip a lien or a motion to value a lien, which is the same thing, get it to your attorney right away. Anything that is bankruptcy related, get to your attorney immediately. Now, the final thing that I'll mention today, an automatic stay of collection of any amounts owed to the association or requiring the owner to do anything that costs money is imposed as soon as that bankruptcy petition is filed. Meaning, if you're doing covenant enforcement, make sure that your attorney is involved in the decision of whether that would violate the stay or not. The penalties for violating that bankruptcy stay are significant. And the bankruptcy code, just like these fair debt laws we talked about a minute ago, is intended to protect the debtor even to the unreasonable detriment of creditors. So be careful, don't violate the automatic stay. Owners will often use this automatic stay, sometimes over and over, to defer foreclosure sales because it's an automatic stay. So if they file something in the state court that says, hey, I'm in bankruptcy, you can't move forward with a foreclosure sale, the clerk of court will automatically cancel that sale. So expect to see these filed potentially even the morning of the foreclosure sale to avoid that sale going forward. Once they're inevitably kicked out of bankruptcy court, you can reset that sale, perhaps move to amend your final judgment to include the additional fees and costs that were incurred in the bankruptcy. You can also seek to lift the stay if there's no adequate protection of your interest in the property, meaning they're not actually including you in the bankruptcy plan, or they're underfunding you in the bankruptcy plan, or the fact that the debtor has no equity in the property. And in Chapters 11 and 13, property is not necessary for the effective reorganization of the debtor, meaning they don't live there, they're not doing anything with the property, etc. Okay, we can go into a lot more depth. You're welcome to email me or call about these bankruptcy and collection issues, but because we are out of time, I want to make sure to get to the Q&A. I'm going to give you guys a couple minutes. Jeff, if you can jump on and let us know what questions we have at this point, I'll be happy to get into some of those now.
Just give me a minute, have a sip of water. I want to go over one quick time here for folks who need to head out and may not have yet done the evaluation. And I turned off the Q&A, but all 8 questions that were in there, I have them here and we will go over them in just a moment. So there was a link in the chat area. In the chat, that link will take you to this page. This is review for some of you who came on early, but for those of you who came on later. After you fill out the evaluation and you hit submit at the bottom, I'm hiding my tabs here. Hang on a second here. You get a confirmation screen that looks something like this. This answers a couple of the other questions. How do you get today's slides? After you hit submit, this is your confirmation screen. You can go ahead and print it, but I'll show you that in a moment. Here is a link to get the slides within the yellow shaded boxed area. So after you hit submit, this screen pops up on your computer and you can click there to get the slides, and there they are. You can then go ahead and save them or print them. I recommend saving them and just pulling them up whenever, because this will take up a lot of ink and toner with the yellow in the background. So save them digitally and save yourself some ink and paper. And then when you have the certificate showing, go underneath it. If you want to print it and save it, you can click that. Your printer dialog box will open up. You can choose your printer, go ahead and print and file your certificates. And if all else fails and you can't figure out how to do that, just take your smartphone, take a picture of it, and you can email it to yourself that way as a last resort. So with that said, I will go ahead and read our first question. Full disclosure, which is, I guess, attorney language, even though I'm not an attorney. And so, I was asked by Mr. Rembaum, by Jeff Rembaum, to clarify. I get a lot of questions sometimes with people thinking that I am Jeff Rembaum. No, I am not the attorney. I am Jeff Solomon. So, Jeff Rembaum, if you were watching somehow, I did it. I clarified that I only play an attorney. It's Halloween. I'm a fake attorney. I am not Jeff Rembaum. So here's our first question. And the full disclosure is that I was doing some other firm work while the webinar was happening. So if some of this is repetitive, just give me a digital slap on the wrist and I'll move on to the next one.
All right.
First question is, if the reserves have been misrepresented to members, is that grounds to not pay the assessment?
Not most of the time. It depends on what the mischaracterization was. But the bottom line is, I don't know that that's necessarily a budgetary issue. It just depends on what the mischaracterization was. Generally speaking, I would say that's probably not a basis to refuse to pay assessments.
Okay.
And frankly, if you take the risk of refusing to pay assessments, you will end up with significantly more interest, late fees, attorney's fees, and costs that you will need to pay to avoid a foreclosure versus challenging the budgetary process in and of itself. So as a practical matter, I think it's a bad idea to say I'm not going to pay assessments because I don't agree with the reserves that are included in them.
Okay. Question number 2, in the first right of refusal for the HOA, would there be a foreclosure sale if the HOA wants to buy it? I guess, can they jump in first and stop a sale?
So rights of first refusal generally don't apply to a foreclosure context. So a right of first refusal is someone is intending to sell the property. That has nothing to do with a foreclosure. So when you talk about right of first refusal and you distinguish that from a foreclosure auction, pretty much anyone has the right to bid at that foreclosure auction, except for the directors, officers, managers, and their families. So they are two completely separate issues. There's no relationship between a right of first refusal and a foreclosure sale. It's only if it is a voluntary sale that the association has that right of first refusal. Now, if that foreclosure happens, someone buys the property at the foreclosure sale, and that person then goes to sell the property, that right of first refusal will most likely kick back in, depending on the language in your governing documents.
Okay. This next question is one of the reasons why I don't read people's names who ask the question. And this came up at the expos that I'd met some of you at this past week in the Tampa Bay area. Our association does selective enforcement of late fees and interest. What precedent does this set? I mean, I think we know the answer, but maybe touch briefly upon that a little bit.
Well, you know, the good and bad news is that selective enforcement generally won't apply in a collection context. You've got the obligation to pay the assessments. The association is collecting the assessments. If you were ignoring the assessments as to one owner and not ignoring it as to the other owner, and you didn't have a business reason to do that, for example, one owner is in mortgage foreclosure, you're not collecting against them. The other owner has no mortgage, you are collecting against them. That would be a basis to say there's no selective enforcement here. So I just don't see demanding interest and late fees from one owner versus another. I don't see that as selective enforcement. I do see it as a bad idea.
Yeah.
Bottom line, you should be applying a written collection policy across the board. So if you're going to waive interest and late fees for one owner, unless there is a business reason, or for example, someone refused to pay assessments for 5 years and now is suddenly coming back and saying, I'll only pay if you waive the interest and late fees. Well, okay, that might be a business reason to say, no, we're not waiving this to you. Whereas another owner comes back and says, I had no idea I was delinquent by 3 months. You guys have charged interest and late fees. I'm going to pay you in full tomorrow. Can you please also separately waive the interest and late fees so that accounts for full payment and you guys are made whole?
Yeah, being reasonable and selective enforcement are two different things. And if you are going to be reasonable with something when making your choices, you must explain why.
Well, you
Are,
don't necessarily need to explain why. You just have to have an explanation available if it reaches a courtroom.
yes. This should be a quick answer here. Are condo owners allowed to find out who is late?
Yes, that's called a records inspection request, and you would just look at all the ledgers for everyone in your community. The association can't send that information out on purpose and say, hey, everyone, here's a late person list, or here's the scumbag list. But you can, if someone sends a proper records inspection request, the answer is yes, that person is entitled to see every ledger in the community.
Okay. This is not a quick one. What does a typical collection policy look like? And then it was clarified, what are the main points? What are the main things that should be included?
Sure. So it actually is a fairly quick explanation, even though it's a 2-page document. So you're basically going to say, what is a delinquency in this community under the governing documents? What are the interest? What are the late fees? Do we have interest or late fees? When will they be charged? When is the first notice going to go out? Is that going to be from management, or is it going to be directly going to the notice of late assessment? And once that notice of late assessment is sent, who's going to send the next notice and file the lien and send the next notice? Is it going to go to counsel, or is it going to still be involved with management? Is the board going to have any discretion whatsoever going forward as to the speed with which this moves forward, unless there is some intervening factor like a mortgage foreclosure or a bankruptcy? The answer to that should be no. The board shouldn't have to get involved in this process at all if you've got a written procedure in place. It's just, well, the owner's delinquent. We have automatic discretion. Well, not discretion. We have the instruction via this policy to continue moving this forward until the owner pays, unless something intervenes that counsel feels it is appropriate to place it on hold or stop the collection activity.
Okay.
So those are the basics. Some people will also put in there what the criteria would be for waiving interest and late fees, what the criteria would be for automatically having counsel or the management firm accept a payment plan if one is requested, what the criteria are for the consequences of violating that payment plan, things of that nature.
Okay. Just a couple of follow-ups, and the chat, I turned off the chat. The chat is not meant for Q&A for the attorney, for Alan. The chat is meant for technical questions if you're having trouble with the evaluation. So I turned the chat back off. I don't want to confuse anybody. There's a couple of quick follow-up questions in the chat. Then I'll move to the last 2 questions in the Q&A. If an owner wants a copy of their ledger, are they entitled to view it? You kind of touched upon that.
Yeah,
and if so, does the ledger have to come from an attorney, or can it come from management, or can it come from the accounting firm?
It can come from whoever, but if the account is with the attorney for collection, I would strongly recommend that before the management firm provide those records, that they get an update from counsel as to what the fees and costs are as of now, so that if you are giving that information out, you're either explicitly saying this is not a full payoff, or you're including those fees and costs and saying, if you want to pay this off, here's what you actually owe, not just here's what we've put on your ledger.
Okay.
So it doesn't need to come from an attorney, but the attorney should be involved if it's with counsel for collection.
Absolutely. Play it safe.
Yeah.
Does it all apply to HOAs as well as condos? Just clarify, and cooperatives as well. We might as well throw that in there.
Condo co-op across the board. This is a standard records inspection request that the association, regardless of what type of community association in Florida, they're all going to be required to comply with that.
Okay. And then we talked a lot about assessments today. Can it also be foreclosed if, I'm going to try to make sense of it's a kind of a broken sentence. Can you also foreclose if not able to pay 100% of added reserves? I guess with all the new insurance things and everything that's going on after the
bottom line, the association. So the question is with I'm presuming this is a condo context, with all of the new structural integrity reserve studies and the new mandatory reserves that a lot of condos and co-ops are required to include in their budgets now. The answer is yes. And frankly, I expect that there will be an uptick in foreclosures for people that simply can't afford to pay all of those reserves as part of their assessment. You do need to include it as part of the assessment. And if people can't pay it, then either the association can potentially get a loan to pay that off, or the owners can get an equity loan against their property.
Yeah.
But yes, it can be foreclosed regardless of what type of assessment it is. It can be foreclosed pardon me, if it's not paid and paid on time.
Okay. And now we are down to the last couple here. What is the proper method for a board to discuss and approve a collection plan at a board meeting, or can it be or the exact verbiage here, at a board meeting or a closed board meeting?
It shouldn't be a closed board meeting because you shouldn't be discussing any particular potential litigation or existing litigation. It should just be, here's what the board wants to do. So it is an open board meeting. An alternative that you could use, because this is just something that's going to apply across the board, is a written resolution, unless that's something that your governing documents say you can't use in place of a board meeting. So those are the two options. It should not be a closed legal meeting of the board, because frankly, there's just no litigation that's being contemplated. This is an entirely general concept that applies across the board. There's no specific lawsuit that's being contemplated that would justify a closed meeting.
Okay. And the last question, and before I get to the last question, I'm turning on the chat now, but that is just for me, not for attorney questions. That's if you're having issues with the evaluation or have non-attorney related questions. So the chat is back on for that. If there's a question for Alan in the chat, unfortunately, we will not be reading that. That is just for technical questions. The last question is, in a foreclosure by the association, is the attorney for the association the one that is supposed to be noticing the first mortgage holder of their filing?
There is no notice to the first mortgage holder, because the association can't foreclose that lien. So the only notice you might provide is if the first mortgage actually says that if the owner is delinquent, the lender is going to pay so that the association doesn't foreclose. So generally speaking, it's something that you wouldn't provide notice to the first mortgagee, because they have the right to foreclose separately, even after the association has completed a foreclosure lawsuit. So it's just not something that generally will be done at all, let alone, spending additional attorney's fees and costs to do it.
Okay. Alan, wonderful. As usual, and there were lots of comments that I did not read to you in the Q&A about how great this was and how informative you were. So thank you very much. And thanks to everybody for attending. Brian, thank you for that comment in the chat just now. We appreciate you, and we appreciate everybody for joining us, because we know you have options. I'm going to hang on for a little bit and go over a couple of technical questions that people had in the chat and go over the evaluation one more time. But as Casey Kasem would say, before I do that, Alan, how do people reach you? Even though I have your email right on there, but what is, please let everybody, your closing comments, your closing statements, please.
Good. We'll go with that. The easiest way to reach me is my email. I don't necessarily respond at all hours of the day, but at least then you'll reach me the next time that I check my phone, frankly. It's as@kbrlegal.com. That's if you've got any questions about anything we discussed today, anything that you might want to discuss about your community, if our firm can help you out. I know Jeff is going to include in the survey a little check mark or a checkbox if you want us to reach out to you regarding your community, any issues whatsoever. But if you want to reach out to me, you're also welcome to do that if you've got something that needs to be handled pretty much right away. Just shoot me an email. I appreciate everyone showing up today and hopefully sticking around. I know we went a little over, and I appreciate especially the over 100 people that are still here now. And I hope everyone has a fantastic afternoon. Thanks for listening.